Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to the NPTEL online certification course Medical Law. As in the previous lectures we have gone through the various modules, and today we will be discussing about the third module with the lecture 15. Myself Dr. Chaitanya Mittal, medical legal consultant at Dr. B.C. Roy Multi-Speciality Medical Research Center, IIT Kharagpur. So, today we will discuss on lecture 15, testimony of doctors in medical negligence. So, the various concepts or the topics which we will covering in this lecture will be the medical negligence, what are the defenses available for the doctors in any case of trials of medical negligence cases, which can be the no legal duty to care, no harm caused, voluntary non-fit injury, accident, necessity, acted to benefit or in the good faith towards the patient, contributory negligence, in a case of emergency, any complications happen, injury not related to medical procedure. So, these are the various new concepts which we will be discussing step by step in further slides. We will come through these new topics in this lecture. So, the various important keywords of this lecture: medical negligence, medical practice, doctor's duty, medical profession and good faith. So, the medical negligence we have discussed in the previous lectures also of our module 3rd on medical negligence and medical malpractice. What we mean by the medical negligence? It is an act of commission and omission. So, it is an legal concept that refers to the failure of a healthcare professional or a treating doctor or a treating physician to provide a standard of care that meets the required level of competence and skill. This failure can lead to harm or injury or damage to the patient and can occur through an act of omission or commission by the healthcare professional or a treating doctor. In professional negligence cases such as medical malpractice, lawsuits filed against physicians, the specific duty owed by the physician to the patient is defined by the profession itself. So, the things happened in a medical negligence by the healthcare professional or a treating doctor towards the patient can be the lack of reasonable skill and care, or the act negligently done or happened, or can be an accident or can be a mishap. But if it is very much clear that there is an negligent act done by the treating doctor, it will be as a medical negligence. So, the Indian courts have adopted the various tests, various guidelines on the various judgments have come up by the apex court. So, they have adapted the Bolam test propounded by the McNair J in Bolam versus Friern Hospital Management Committee in the year 1957 in the United Kingdom, which we discussed in detail in the previous lecture. The Bolam test articulates the standard of the ordinary skilled man exercising and professing to have the special skill and not of the highest expert skill. So, there should have a reasonable skill and due care to be taken, not necessary to be having the highest expert skill. Reasonable skill and care need to be there or need to be exercised by the treating doctor towards the patient. This is applicable to both diagnosis as well as the treatment of the patient. The Supreme Court in the Jacob Matthew versus State of Punjab and another in the year 2005 states that a mere deviation from normal professional practice is not necessary evidence of negligence. Let it also be noted that a mere accident is not evidence of negligence. So, an error of judgment on the part of professional is not negligent per se. Higher the acuteness in emergency and higher the complication, more are the chances of error of judgment. So, if it is a minute mistake, it is not be considered to be as a negligent. It has to be clearly following the guidelines which are being mentioned by the Apex Code, then only it will be considered as to be as a medical negligence. In the case of Spring Meadows Hospital versus Harjol Ahluwalia in the year 1998, the Supreme Court held that mere error by the doctors which entailed undesired results does not constitute medical negligence. V. Kishan Rao versus Nikhil Super Specialty Hospital in the year 2010, Supreme Court cases 513. The Supreme Court has applied the famous Bolam test and observed that a doctor is liable only if he has breached the duty of care. The 4 D's, that is the duty, dereliction towards the duty, or direct cause or any damage. So, if it is the doctor or the treating professional has breached the duty of care towards his or her patient, and the doctor need to observe the skill which has set out in the medical profession, then only the doctor will be held liable. The Bombay High Court in Venkatesh Iyer versus Bombay Hospital Trust and others in a year 1998 observed that there are black sheep in the noble medical profession also, but it should not be forgotten that the angels are still very much there in the very same profession. The court also held that if doctors have not acted negligently, they cannot be held liable unnecessarily. So, there are the various defenses which are available for the doctors in case of any trials or in case of medical negligence cases happen in their medical practice. No doctor knows everything. There is a reason why it is called practicing medicine. When a doctor gives a patient the best care possible in line with medical standards, but the procedure fails to turn out as planned, the patient or the legal heirs may file a lawsuit accusing the doctor of medical negligence. In such cases, the doctor may be able to use one of the various defenses available to shield him or her from liability. So, the defenses will also be applicable when the doctor has followed his own reasonable skill and care, proper guidelines he has followed, then only the defenses will be applicable. So, doctors are one of the most important pillars of society, and they do the pious work of serving sick people towards the humanity. There are the certain instances that are unforeseen for doctors and patients. In these cases, doctors cannot be held liable. A society shall not make it a routine practice to blame medical professionals for any loss suffered while taking medical care. So, the various defenses which are available are the no legal duty to care. The first and foremost D in the medical negligence is the duty. The doctor has a duty or not? The particular at the time of diagnosis or the treatment, the doctor was having duty or not. If no legal duty to care, then how the doctor can be held liable? Or no harm caused. If there is no any physical damage happened to the patient, then it can be considered as a one of the defense. No harm caused. Voluntary non-fit injurer. We will discuss this in further slides. What do you mean by it? Voluntary non-fit injurer. In case of any accident happens, like anything while doing the operation table, due to any infrastructure, administrative, any instrument failure, any accident can happen, or while shifting the patient in an ambulance, another accident happen. So, anything can possible. Necessity, the particular instrument need to be there in between the operation, and it is not available by the given by the administrative or not available in the hospital infrastructure. So, anything is there. So, it is in that case alone the doctor is not held liable, acted to benefit the patient. If the doctor in case of emergency has done any procedure or a treatment in the benefit of the patient, contributory negligence, it is not only the doctor is liable. If any guidelines or any counseling being done to the patient and patient has not taken a follow up, has not done her own part, then the contributory negligence. Also there can be a involvement of hospital. So, it is not only the doctor will be held liable. So, if there is any contributory negligence, the people or the parties who are involved in that all can be held liable. In a case of emergency, the doctor has done the treatment in a good faith to just save the life in emergency. In case of any complication, in a new complication phase in particular operation which is not being there in the literature, anything miracle is happen in a medical practice, injury not related to medical procedure, something else has happened due to not due to that particular diagnosis or the treatment or the operation happening to the patient, but something else. So, that has been discovered later on. So, these all can be the defenses. We will discuss step by step with an example. So, the first and foremost, no legal duty to care. So, a duty of care is a legal obligation to avoid causing harm and arises where harm is reasonable, forcible, if care is not taken. So, there should have a doctor should be have a duty. So, that is the first and foremost. The doctor is at the time of treatment, he is on or her duty or not. So, if there is no legal duty to care, then how he or she can be held liable. So, then only if there is a no duty, then there will be no dereliction of duty. So, if the person is on duty and if there is a dereliction or breach to the duty, then the doctor can be held liable for any negligence happened to the patient while undergoing the treatment or any procedure. So, there must be a sufficient relationship of closeness and proximity between the two people, that is a patient and the doctor or healthcare professional, in order for a duty of care to exist. If doctor has not seen that patient, how he can be held liable? So, the duty terms come when there has a relationship, doctor patient relationship, healthcare professional and the patient coming to that. If doctor has seen the patient, then the duty established, is a relationship established. So, if not seen, then how the doctor can be held liable? So, no legal duty to care is also an important defense towards the medical negligence cases. Particularly in medical negligence claims, a doctor cannot be held liable if he or she is not under a legal duty to take care of the patient. Hypothetically, if a patient went to a hospital and after a checkup the doctor referred him to a specialist, and the patient cannot claim medical negligence on the part of the doctor, since the patient is not under a legal duty to provide specialist medical care. Definitely. So, the doctor means the patient has come to a particular first doctor for a treatment. He has given his first aid or as per his skill and expertise and then referred it. So, the patient can't say that the doctor has not done a expertise treatment or a specialist treatment, as he is not there. Even if he does so, then he will be held definitely liable if any mishap or any damage happen, because that is not under his skill. So, the doctor has done his good work in referring the patient, but then if there is any delay in by the patient side not going to that referred doctor, then it is not a first doctor to be held liable. So, if there is a duty to care, then only the doctor can be held liable. If there is no duty established, no relationship established, then it is difficult to go, or it can be an important defense towards doctor. Next, no harm caused. So, while practicing medicine, doctor needs to make hard decision for the treatment of patient. Definitely, there are a lot of type of treatments are available for a particular diagnosis or particular disease. So, which treatment suits well or give a good prognosis? It is difficult to make out. So, when a specialist doctor opts for an alternate treatment by looking at the condition of the patient at the last minute, it might cause discomfort for the patient, but it does not constitute negligence, because anything can be needed at a particular time. By seeing the different investigation, anything new can come up. So, different alternative treatment can also be available. So, this can be done by the doctor side by counseling the patient. It can counsel the patient, make a proper documentation that this treatment is good for your condition and having a good prognosis. So, no harm caused is also an important defense towards the doctor in a medical negligence claims or cases. The patient had given express consent in writing to perform only laparoscopic surgery, but the appellant, instead of performing laparoscopic surgery, proceed to perform conventional open surgery, and the patient felt discomfort after surgery. But this decision of the doctor is not negligent. Why? Because if sudden any changes is needed, any condition because of that particular condition of the patient, so definitely if there is an consent for a laparoscopic surgery, so the counseling to the patient need to be done before starting for a conventional surgery, and the consent need to be taken, but that does not mean that laparoscopy converted into open surgery definitely with the consent of the patient is held negligence towards the doctor, but the consent is necessary, counseling to the patient is necessary before proceeding when even any alternative treatment. If without proceeding, if without taking any consent, then the doctor can be held liable. Otherwise, it is not, doctor will not be held liable for going for another treatment. It is being counseled, it has been taken a consent, it is for your good prognosis, that is only the solution for your condition. So, it has been completely explained to the patient, counseled, taken a consent, then the doctor will not be held liable for changing the treatment at a particular last moment. Next, voluntary non-fit injurer. Whenever a patient is in need of medical aid, he is exposed to some kind of risk. The assumption of risk arises at the start of treatment. The voluntary non-fit injurer principle states that no one can demand an action if they have freely consented to it. If the doctor has given if the patient has given a free and voluntary consent for a particular treatment to the doctor, then they can not demand any action. No one can demand an action. Okay. The voluntary non-fit injurer principle. For instance, even with the appropriate radiation therapy, radiation burns may occur. This is not carelessness. However, if burns are consequence of excessive exposure, the sufferer is entitled to claim. So, if anything has happened within a consent part, within a reasonable skill and care, within his or expertise, the doctor is not held liable. Otherwise, it can be held liable. So, the minute burns due to radiation therapy are not a carelessness, but if excessive happened, then definitely the sufferer can go towards a claim for a medical negligence. Supreme Court decision in Chandarani Akkuri versus MS Mathusudapati Mithupati in a year 2021, Supreme Court cases 291, where in the court held that no doctor can ensure a full recovery in every case. Definitely, the doctor will do the treatment with his own, give a best interest or best treatment within his reasonable skill and care, but that does not mean the full recovery will happen like or 100% treatment. So, no doctor can ensure the full recovery in whatever being the condition. So, in case of accident, one of the defense towards the doctor in case of medical negligence cases, an unintentional, typically undesirable incident that was not directly caused is known as to be an accident. The word accident suggests that no one is to blame, though dangers that were ignored or overlooked could have contributed to the occurrence. Section 80 of the Indian Penal Code 1860, which deals with then the word accident. If any person is doing a lawful act by lawful means and then any misfortune happens, that person cannot be held liable. So, this is also an important defense in case of any accident or any mishap happened unknowingly, unintentionally while performing the procedure or while undergoing any treatment. So, the doctor or the treating physician will not be held liable for that particular accident happened during that time. The medical profession is not the risk free, and the doctors cannot predict everything beforehand while providing medical care. Definitely, doctor is not a god. He can just try his best within his own expertise to do the treatment, to do the best or benefit towards the patient. So, the doctor does not know everything before starting the treatment, any complication, but he can give an counseling to the patient, anything the risk and the benefits can be involved with this particular procedure. So, if the doctor has properly documented, properly counseled, proper consent being taken, the doctor will not be held liable. So, the main thing is the documentation, counseling the patient, taking the consent. For an instance, if a patient is admitted to the hospital for surgery, before the surgery complications head up and the medical devices that are important for diagnosis are found faulty. In this scenario, the doctors cannot be held liable for negligence. Definitely, the instrument failure or the instrument faulty, it is a part of administration, but it is also necessary towards the doctor side before starting any procedure, any operation. It is good to instruct to the staff that please check all the instruments whether they are working properly or not. But sudden mishap can happen, sudden accident can happen, faulty failure can be there towards instrument side. So, any complications can head up. So, all these are being already mentioned in the consent, but can be explained properly, counseled it. Same principle was iterated by the Supreme Court in Bombay Hospital and Medical Research Center versus Asha Jaiswal and others in a year 2021 Supreme Court cases online 1149 to be as cited. So, if any case of an instrument failure on a faulty device, the doctor is not held liable for any complications arises due to that surgery or the operation or any procedure treatment. Necessity. The defense of necessity can be raised by the doctors if the act done by them causes harm, but it has been done without intention and also to prevent other harm. However, the risk of doping such an act will be weighed against the nature and need of each situation. In the medical profession, sometimes doctor need to make some decision which might invite negligence claims, but the doctor needs to undertake the gravity of the situation and the intentions of performing doctors. So, there is important defense, that is a necessity. Acted benefit to the patient towards the benefit or in a good faith, definitely with a consent. If any person caused injury acting on behalf for the benefit or good faith towards the patient with the consent of that person has not committed any offense. But in case of emergency, definitely without consent also towards as a benefit or in a good faith is not considered to be as negligent or liable. So, definitely with consent, if doctor has done any act in a benefit towards the patient, the doctor has not committed any offense if anything mishappens. The rule of consent cannot justify an intentional causes of death, but a person for whose benefit an act is done may consent that another shall do that act even if the death may probably ensue, although the doer never intends death. Definitely doctor not want any damage happen to the patient. Always doctors is towards the benefit or in a good faith the procedure has to be done towards the patient condition. But any mishap can happen, even the damages, even that can lead to the death. But if the act done in a good faith for the benefit of the patient, unintentionally any mishap, damage or death has occurred, the doctor is not held liable for it, as he has taken the consent, explained it properly, the complications, the risk towards the operation or surgery, and the act is being done in a good faith or for the benefit of the patient, the doctor is not held liable. Under section 88 of the IPC 1860, doctors can take the defense that they were performing the procedure with the consent of the patient and were acting in good faith for the benefit of the patient. For instance, a surgeon, knowing that a particular operation is likely to cause death of the Z who suffers from a painful complaint, but does not intend to cause Z's patient's death and intends in a good faith of the patient's benefit performing that operation on patient with his consent. So, the doctor has not committed any offense, will not be held liable if any mishap or even death has occurred, as the doctor has not intended it. It has done the act in a good faith for the benefit of the patient. Even the is likely, it has explained properly, there are the chances of poor prognosis, but has explained properly, patient has agreed to it, yes, definitely you can proceed. So, the doctor, if any mishap happened, doctor is not held liable or not committed any offense as act is done in a benefit of the patient with consent. Coming to the contributory negligence occurs when an individual does not act in a reasonable and careful way that might result in harm to himself. When the plaintiff contributes to the incident, his role should be duly regarded when liability is determined and the quantum of damages is assessed. It is not an absolute defense from liability, but recognizes a limited liability of the doctors by relatively reducing the damages. So, definitely in a case of contributory negligence, if patient has not done the follow up, doesn't done his duty or his role towards the treatment or care by patient which has been explained by the doctor, which is being documented, then the doctor's negligence being reduced if any mishap happened. Definitely the doctor will be held liable if any gross negligence has occurred, but the patient's due to the patient negligence, the damages or the claim or even the punishment can be reduced. Contributory negligence of a patient is any unreasonable conduct or absence of ordinary care on the part of the patient or his personal attendant which, combined with the doctor's negligence, contributed to the injury complained of as a direct proximate cause and without which the injury would not have occurred. So, the National Consumer Dispute Redressal Commission NCDRC in the case Devender Singh versus Vivek Pal in a year 2013 442 observed that the patient was using medicine against the medical advice of the doctor. Thus, the doctor is liable to only a limited amount of compensation as this mishap happened, has not maybe not counseled properly, maybe documentation is not there, but if doctor has not prescribed that medicine or something else is there, so he is done against the medical advice or not following as per the prescription of the doctor is not held liable alone. The patient's role is also there in case of gross negligence. If it is minor negligence and it is completely the fault of patient, even the doctor will not be held liable for even a single penny of compensation. So, in case of emergency, in emergency scenario everything changes, it is always done now the part is to save the patient's life. So, there is nothing normal even in normal medical procedure. A medical emergency is an injury or illness that is acute or poses an immediate risk to a person's life. So, it is necessary to save the life of the patient or a person. Attending to emergency medical problems is the responsibility of primary doctors and they should be armed with the knowledge, skills, staff, practice, equipment and medication to manage patients effectively, which may even be life-saving treatment or procedure. The Supreme Court in a case Dr. Harish Kumar Khurana versus Joginder Singh in a year 2021 Supreme Court cases SC 673 held that hospitals and the doctors are required to exercise sufficient care for the patient in all circumstances. However, in an unfortunate case death may occur. It is necessary that sufficient material or medical evidence should be available before the adjudicating authority to arrive at the conclusion that the death is due to medical complication, which is also a defense for a doctor. So, the देवेश जी मुझे ये बताना था, जो पहले मैंने इस स्लाइड के बारे में बोला था ना, उसके कंटिन्यूएशन में ही मैं बता रहा हूँ, ये स्लाइड रिपीट नहीं कर रहा, ठीक है? हाँ, तो कोई कटिंग नहीं करना है एक्सेप्ट ये मेरा कफ पार्ट, ठीक है? स्टार्ट. सो द कॉम्प्लिकेशन which is as a defense towards a doctor in case of medical negligence is an also very important defense. So, any side effects can happen which is already being known complication, has explained, the doctor has explained to the patient regarding the non complication, non side effects, but any can miss or new side effects can come up. For an example, in case of penicillin injection, already we have explained. So, but if doctor has not done any sensitivity test properly or not documented, or if any anaphylaxis shock can happen and the management is not available, then the doctor or the hospital is liable. But if the doctor has done all sensitivity tests and management is also being available, still any mishap happened after penicillin injection, maybe because of the patient body or any mishap happened. So, the doctor, if has done properly documentation, proper concern with a reasonable skill and care, proper guidelines followed, then doctor will not be held liable in case of any mishap or any case of anaphylaxis after penicillin injection, after following the proper procedure and the guidelines. So, coming to the next defense, the injury not related to medical procedure. The defendant's failure must have been the direct cause of damage to the plaintiff in order for the defendant to be legally liable for negligence. Definitely, if there should be have a legal duty, then there should be a breach or dereliction towards that duty and direct causation. There should have a direct damage to the plaintiff to held liable, and the damage should be obvious. There should be a physical damage or even death. So, then only the plaintiff can file a case towards a doctor. Simply because a patient has not favorably responded to a treatment given by a doctor or a surgery has failed, the doctor cannot be held straight away liable for medical negligence. If doctor has followed everything properly, properly documented, properly concerned, any failure happened, not responded properly, that direct cause is not there due to medical procedure, the doctor will not be held liable for that particular medical negligence happened due to the procedure or a treatment towards that patient. For an example, if doctor fails to diagnose a patient with heart disease when a similarly trained physician would have, and the patient has a heart attack caused by that heart condition, the doctor's failure would be the direct cause of injury, definitely. So, he has failed to diagnose it properly. Even his expertise is there, but he has failed. So, direct cause is there. But if patient dies of cancer and turns out the autopsy reveals that had a heart condition that was missed, the patient's surviving family members can pursue a negligence claim against the cardiologist because his actions did not cause the harm. Definitely. So, if patient has died due to the cancer, not due to the heart attack, and if any cardiologist or if any doctor has not told that you are suffering from this heart disease, so that doctor will not be held liable, as the patient direct cause is not there. That cause, if direct cause is established, then definitely the doctor is held liable because of that heart disease, this cancer has leads to a death. But if that doesn't such so, direct cause is not there, the death is due to something else, and later on a postmortem examination find out the heart disease is also there, which has not been informed by the treating doctor, then the treating doctor is not held liable for that missed diagnosis. The Supreme Court in Mrs. Kalyani Rajan versus Indraprasth Apollo Hospital and others in a year 2023 Supreme Court cases 135 has stated that no case of medical negligence if complications were suffered by a patient totally unrelated to the medical procedure undergone. If medical procedure on something else, it is due to on the bone part or something on the liver or something from other diagnosis, and the patient has died due to some other reason unrelated, the it's not a part of a medical negligence. Doctor will not be held liable. But if it has been proved that there is some direct causation, then definitely doctor will be held liable for missing the diagnosis or the medical negligence happened to the patient while undergoing any procedure or treatment. So, the recent judicial trend on medical negligence, the National Consumer Dispute Redressal Commission in Mohit Jain versus Max Super Specialty Hospital and others in a year 2023. The Consumer Protection Act should not be a halter around the neck of the doctors to make them fearful and apprehensive of taking professional decision at crucial moments to explore the possibility of reviving patient hanging between the life and death. So, the NCDRC has come up with this judgment that should not make the doctors fearful, let them do the safe medical practice. The commission also observed that in order to establish medical negligence, the victim or victim's family bringing the action must prove the 4 Ds against erring doctor or hospital, which include famous 4 Ds, that is the legal duty towards the patient by the doctor, dereliction or deviation of that legal duty, direct cause has happened or approximate cause linked with that procedure and treatment towards the patient, and the last is damage which has happened to the patient. Should not confuse with the damages. Damages is completely a compensation or the claim part. So, we will discuss with this judgment. Ms. Divya Chauhan versus Dr. S.P. Agarwal, Delhi State Consumer Dispute Redressal Commission held that in cases involving allegation against medical professional, negligence is a crucial element of the offence, which involves the failure to perform a duty by omission that a reasonable person would do or avoid doing, act of commission or omission. The negligence cannot be automatically assumed in unsuccessful treatment. If any unsuccessful or any mishap is there, directly does not consider that it is a medical negligence case. It has to be followed proper guidelines, establish the 4 Ds, then only it can be considered as a medical negligence. Dr. Pramod Batra versus Medical Council of India and another in a year 2023, online Delhi 3759, while failing from the minimum standards of medical practice, has no justification for dispensing medical treatment, and it displays negligence to the welfare of a patient and has to be dealt with severely. It is equally true that the scalpel cannot be wielded by a shaking hand. Baseless targeting of doctors, unmindful of the consequences, is bound in the ultimate eventuate to seriously prejudice public interest. So, coming to the conclusion of this lecture, the medical negligence is a serious threat to the health of the patient as well as to the society and should be dealt seriously. It is noteworthy here that there are the differences between the negligence and any act unforeseen even for the doctors, and the courts should demark the same in a religious manner. Doctors are an important part and pillar of society towards even humanity. Thus, it is necessary to protect innocent doctors and not to threaten them with unnecessary litigation in a medical negligence claims or trials. So, it is necessary for the doctor side to follow the proper guidelines being mentioned towards the Supreme Court or Apex Court, that properly documentation, proper concern, proper counseling should be there at each and every step of the procedure and the treatment. And for the law enforcement agencies and the courts, that if the doctor is doing his safe medical practice, should not make them fearful or given protection, or should not disturb them with unnecessary litigations or the trials in a court. So, these are the references you have all can go through for the further readings from the year 2009, and another article is also from the 2009 from the famous journal PubMed articles, and last also is a article from the year 2016. So, you all can go through these references for further understanding on the various defenses of doctors in a medical negligence cases. Thank you very much.